Okay, here I am. Jax West from Stephen Avery Project, Justice with Jax. And now my screen went blank. There we are again. And MAM Gossip. Thank you to the person who sent me that the state responded today. I never say people's names when they send me stuff because, you know, never know if they want it to be secret or not. So don't think I'm not saying your name because I don't want to give you credit. I will happily say your name if you wanted me to. But thank you for sending it to me today. And I have not read this yet. I read it as we go. So this is the state's response to Kathleen Zellner's last filing. Also know that I make the settings on here that in order to comment, you must be a follower of Stephen Avery Project. I just try to stop the guilters because it's just less work for me and Christopher to delete things when people want to post that they think Stephen is guilty. This, as I've said a million times, this is a supporter page. We believe or know that Stephen is innocent, and so this is not a place to debate guilt or innocence. All right, I'm gonna start reading. Um, and oh, I should have grabbed the link to post in here, and now I can't on here. Um, so I'll get this posted at some point, the link for people to go and read this themselves. When I'm reading, I may be looking down at the page, not here. So if you ask a question and I don't see it, I'm not ignoring you. It's because I'm looking here. All right. I try to look up and go back and forth. All right. This was filed today, April 15th, 2024. Issue presented. And even with the title of this section, issue presented, it has a footnote. And the footnote for that says, below, Avery alleged that the state violated Brady versus Maryland. On appeal, he mentions that he raised Brady claims, but he makes no argument on them on appeal. He has thus abandoned them. The state will not discuss them further. Snap. All right. Did the circuit court properly exercise its discretion to deny defendant appellant Stephen A. Avery's third Wisconsin Statute 974.06 motion without holding an evidentiary hearing because his claims of newly discovered evidence were insufficiently pled and refuted by the record? The circuit court issued a thorough opinion fully explaining the numerous failures in Avery's motion to plead facts that would meet the legal elements of his newly discovered evidence claim and show that they weren't otherwise defeated by the existing record. It properly exercised its discretion in denying the motion without a hearing. This court should affirm. Next section is titled Statement on Oral Argument and Publication. Neither oral argument nor publication are appropriate. This case deals with application of well-settled law to the facts, which are adequately addressed on briefs. Next section is titled Introduction. Avery has once again misunderstood the pleading standards and the scope of this court's review. He simply attempts to convince this court that his latest defense theory, pinning the murder on Bobby Dassey, has merit, and in his appellate brief, attempts to cure the pleading failures in his Wisconsin statute motion identified by the circuit court. Accordingly, Avery says much about why he believes this defense is viable, but almost nothing about the sufficiency of his pleading below. The only issue before this court is whether Avery pled sufficient non-conclusory facts within the four corners of his third section of the motion. He did not meet this burden. Motion to entitle him to a hearing. The circuit court correctly concluded he did not meet this burden. Avery's motion, again, contained nothing more than conjecture and unsupported speculation, and even assuming any of it were true, it did not establish what he claimed. He failed to show that he could meet the Denny, and there's a footnote that is just saying nothing of note for us. Meet the Denny test as to Bobby Dassey, and he failed to even try to explain how there was a reasonable probability of a different result at trial if he offered it. As this court explained previously, quote, key to any motion are sufficient non-conclusory showings, why the claim has facial merit. These requirements are not optional and cannot be met by broad conclusions or by misstating evidence, unquote, and another footnote that is just another rule, Wisconsin statute rule. There we go. Broad conclusions and misstatements of the evidence are again all Avery provided, though. The circuit court appropriately exercised its discretion in denying Avery's motion without a hearing. Next section is titled Statement of the Case. This court has reviewed the underlying facts of this case multiple times, so the state will not relay them in detail here. And another footnote that doesn't matter. The state instead provides this overview of Avery's post-conviction litigation. And we're not going to go through that. It's just the history of the case. All right, so next section, argument. 1. Avery failed to plead sufficient facts in his motion that would meet the newly discovered evidence standard, even if true. A. Standard of review. A circuit court may deny a post-conviction motion without a hearing if the facts alleged, quote, do not entitle the movant to relief, or if one or more key factual allegations in the motion are conclusory, end quote. To sufficiently plead a post-conviction motion, the defendant must present within the four corners of the document the, quote, who, what, where, when, why, and how, unquote, that would entitle him to the relief he seeks. Mere speculation presented as fact is a conclusory allegation and insufficient. When evaluating the sufficiency of a pleading, this court reviews, quote, only the allegations contained in the four corners of, brackets, the defendant's, post-conviction motion, and not any additional allegations that are contained in the defendant's brief, unquote. A sufficiently pleaded motion, however, is not enough to require a hearing. Quote, an evidentiary hearing is not mandatory if the record as a whole conclusively demonstrates that the defendant is not entitled to relief, even if the motion alleges sufficient non-conclusory facts, unquote. Quote, this court will uphold the circuit court's findings of fact unless they are clearly erroneous, unquote. Quote, whether a defendant's post-conviction motion, quote, on its face alleges facts which would entitle the defendant to relief, unquote, and whether the record conclusively demonstrates that the defendant is entitled to no relief are questions of law that an appellate court reviews de novo, unquote. Section B. The circuit court did not err in evaluating the materiality prong of the newly discovered evidence test through the lens of Avery's attempt to establish Bobby Dassey as a third-party perpetrator. Avery begins with another argument based on unsupported conclusion he posits as fact. He claims, quote, the circuit court improperly found the materiality of Mr. Avery's newly discovered evidence is exclusively contingent upon its satisfaction of the Denny test, unquote, but instead should have considered whether Sawinski's and Baresh's affidavits were independently material, arguing they rendered the forensic evidence introduced against Avery at trial unreliable, because Bobby was a third-party perpetrator suspect. He then claims, quote, if a third-party suspect had possession of Ms. Halbach's vehicle, numerous areas of reasonable doubt arise, unquote. There are two problems with this argument. First, it is circular. Avery assumes the conclusion he has to prove, that he meets the Denny test as to Bobby to support his claim that, quote, a third-party suspect had possession of Ms. Halbach's vehicle, unquote, in turn making Sawinski's information material. But that assumes he met the Denny test in the first place. Without first establishing Bobby as a potential third-party perpetrator, Sawinski's and Boresh's claiming they saw Bobby with a car similar to the victim's 5 days later is irrelevant and meaningless. Sawinski's information cannot be material if untethered from a viable third-party perpetrator defense, claiming Bobby killed the victim, because there is zero probability that a different... Oh, sorry. Oh, thank you, Jessica. I was just noticing there was comments. I wasn't paying attention. If untethered from a viable third-party perpetrator defense claiming Bobby killed the victim, because there is zero probability that a different result would be reached at trial based on arguments that Bobby could have planted the forensic evidence simply because Sawinski saw him pushing a car down the road. Unless he could argue that Bobby killed the victim, Avery would have to make a context-less allegation that Bobby planted all of the evidence against him with no explanation how or why Bobby would even know the victim was dead or where her car was located, let alone any viable explanation why Bobby would be sneaking around, placing her items and remains on his uncle's property and mopping up Avery's blood and, nonsensically, his touch DNA to frame him. And Avery still conveniently falls to account for the bullet with Ms. Halbach's DNA on it that was shot from the gun in Avery's possession and found in Avery's garage. This unbelievable proposition would not raise any doubt about Avery's guilt with any reasonable juror. So the circuit court properly recognized that Sawinski's allegations are not materially independent from Avery's attempt to meet Denny. The only issue here is thus whether Avery provided sufficient facts in his motion to show he could establish Bobby, oh my God, as a possible third-party perpetrator. So, Bobby, their star witness, who has been contradicted several times, including by his mother and his brother, and that there were multiple witnesses who reported back then that they saw Bobby Dassey with Teresa Halbach's vehicle. The state is trying to claim that reasonable juror will get doubt. There's absolutely, at the very least, would be reasonable doubt when Bobby is your star witness and he's lied. He said he saw Teresa Halbach walking to the trailer, but he told his very own mother he didn't see her do that. That he didn't see her walking to the trailer. He told his other brother, Brian, right? It was Brian that was told he saw her leave. So he tells his mother that he didn't see her. He tells his brother, Brian, he saw her leave. His brother Blaine saw him driving the RAV4. tried to destroy his computer, lied about where he was because his cell phone is pinging in a different direction, and you're saying there's no reasonable doubt from that. And then on the gun, and the casings or bullets, whatever you want to call them, that came from Raleigh Johnson's gun, who testified back then that he shot his gun, that Glenfield, Marshall Glenfield, I don't know, can't remember what that gun's called, all over his property. Because remember, too, Stephen lived there but was renting it. That was Raleigh Johnson property. That was Raleigh Johnson land. That was Raleigh Johnson garage, Raleigh Johnson trailer, Raleigh Johnson gun. All the furniture in that trailer was Raleigh Johnson's except for a bed and a desk. Everything else was Raleigh's, or Rowley. And he testified he fired that gun all the time. Even the day that Teresa Halbach was there, Earl Avery and what's-his-face, Robert Fabian, were driving around in a golf cart shooting at things. It was common. So you're saying that they're not even addressing the bullet with allegedly Teresa Halbach's DNA on it. It's been asked and answered. Watch the second Making a Murderer series. I never remember what the documentarians call it. It's not part. I know they don't like it called part 2. But when Kathleen Zellner is doing her own tests, as she always does, and she was shooting the same kind of gun at the garage. I mean, whatever. All right, let's go back. Second, Avery's argument on this is based purely on conjecture, with none of the necessary facts supplied that would establish what Avery concludes. Again, Bobby was not, quote, the state's primary eyewitness, unquote, no matter how many times Avery declares it. Bobby established only that Ms. Halbach arrived at the Avery salvage yard on October 31 and that he saw Ms. Halbach walking toward Avery's trailer before she disappeared. The state called over 14 citizens, 16 law enforcement witnesses, and 12 forensic scientists who explained the enormous amount of evidence, pointing directly to Avery as the killer. And they were all far more material than Bobby. Over half of Bobby's direct testimony was just identifying photos of the property. Avery fails to explain how attempting to impeach Bobby's testimony about seeing Ms. Halbach arrive on October 31 with Mr. Sawinski's purported evidence would have even been achievable, let alone would have turned the tide at trial. Avery's affidavits establish only that Sawinski and Baresh believe they saw Bobby and some other person with a RAV4 on November 5, 2005. As the circuit court correctly observed, Avery then speculates this means Bobby must have been in possession of Ms. Halbach's RAV4 5 days after the murder, and therefore he must be the killer, and backfills with speculation about the record from that perspective. The circuit court properly rejected this unfounded speculation as insufficiently pled. Section C is titled, Avery's newly discovered evidence claim was multi-layered, requiring application of both Edmonds and Denny. Quote, to set aside a judgment of conviction based on newly discovered evidence, the evidence must be sufficient to establish that the defendant's conviction resulted in a manifest injustice. Sorry, I'm having such a hard time reading today. Unquote. When seeking a new trial based on the allegation of newly discovered evidence, quote, a defendant must establish by clear and convincing evidence that 1. The evidence was discovered after conviction. 2. The defendant was not negligent in seeking the evidence. 3. The evidence is material to an issue in the case. And 4, the evidence is not merely cumulative, unquote. Quote, once those 4 criteria have been established, the court looks to, quote, whether a reasonable probability exists that a different result would have been reached in a new trial, unquote. Here, Avery claimed that Sawinski's and apparently Burrush's later information in a footnote that says Avery makes no argument related to Burrush here and made none in the circuit court. He merely filed Burrush's belated affidavit in the circuit court May 26, 2023. Back up, would permit him to assert a third-party perpetrator defense claiming Bobby Dassey committed the murder. To establish that it is material, then he must have provided sufficient facts to show that it would permit him to meet the legitimate tendency test articulated in Denny and clarified in State versus Wilson. And to meet the 5th prong of the newly discovered evidence test, he had to provide insufficient facts in his motion to show a reasonable probability that a jury presented with his third-party perpetrator defense would have had a reasonable doubt about his guilt. Footnote. Avery's claim that this court is reviewing his constitutional right to present a defense as a matter of constitutional fact is wrong. This court is reviewing only the sufficiency of Avery's pleading. Back up, it says Avery's motion failed to provide sufficient facts that show he could establish either, now another footnote, the circuit court could not find, quote, that Mr. Avery satisfied all the elements required to admit his newly discovered evidence, but for the materiality requirement, unquote. It did not reach that 4th or 5th prongs of the test because it found that Avery could not meet the materiality requirement. Back up. Thus, the circuit court properly exercised its discretion in denying it. And now we're on page 15 of 42. Next section 1. To require a hearing on his Denny claim, Avery had to provide sufficient facts to establish the third party had motive, opportunity, and that evidence directly connects them to the perpetration of the crime. Quote, to present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed the crime. In other words, that the third party had motive, opportunity, and a direct connection to the crime, unquote. A defendant's offer of proof on these 3 prongs is insufficient if it merely establishes a bare possibility that the third party could have been the perpetrator. Rather, quote, it is the defendant's responsibility to show a legitimate is italicized, legitimate tendency that the alleged third-party perpetrator committed the crime, unquote. 2. Avery failed to provide any facts that would establish that Bobby Dassey had a motive for the murder. Quote, motive refers to a person's reason for doing something, unquote. Avery claimed that he pled sufficient facts to establish that Bobby Dassey had a motive to kill the victim because pornography and some gory images were found on the communal computer in the Dassey home. And the footnote says, Avery's claim that this court, quote, pointed out in its opinion previously, unquote, that Denny evidence, quote, must be viewed in the aggregate, unquote, is false. Back up. He then claims that the circuit court erroneously required each piece of his proffered evidence to meet all 3 prongs. The record plainly shows that the circuit court did not do that. It examined the evidence he provided for each prong under the test for each prong. And it reasonably concluded that Avery did not supply adequate facts to establish that Bobby plausibly had a motive to commit this crime. Avery again claimed that the pornography found on the Dassey home computer established Bobby could have had a sexual motive to commit this murder. The circuit court found that he did not provide any facts to support that speculation. This is because he provided nothing that would establish 1. Bobby conducted the searches for the pornography found on the Dassey communal computer, or that he was even at home at the time the searches were conducted. 2. The searches were generic and broad and did not closely resemble anything about this crime. And 3. The 2 psychological opinions he submitted were based on the assumption that Bobby conducted the searches, which was supported by no facts of record, and were produced without any forensic or psychological examination of Bobby himself. Those findings were all supported by the record and not clearly erroneous, meaning the circuit court's legal conclusion that Avery did not plead sufficient facts that could establish Bobby had a motive to commit this murder was sound as well. The record shows that Avery once again failed to supply any facts supporting his contention that Bobby conducted these searches. As this court noted previously, the mere fact that Bobby could have been at home when some of these searches took place fails to establish anything about who actually conducted them, and Avery cannot rely on his computer experts or anyone else's speculation on what Bobby's schedule might have been on those days. Oh, but they can speculate Stevens. Whatever. But speculation based on the timestamps from a fraction of these searches and some generic statements about the home's occupants' usual schedules were once again all Avery provided, with no actual facts about Bobby's whereabouts on the days and times the searches were conducted, nor anyone else's who may have had access to the home. As this court already explained, the existence of the searches is not a fact that would establish Bobby was even in the house at those times, let alone that he was the person using the computer or accessing these images, and Avery's broad generalizations about what the other Dassey family members' typical schedules were does not suffice either. Avery's own submitted exhibit showed that there was no evidentiary support for his allegation that Bobby had a motive to commit this crime. And once again, I ask, what is Stevens' motive? The bulk of the searches for pornography or gory material that Avery relied on to allege motive had no relation to this crime, and either occurred on a weekend when anyone could have accessed the computer, or occurred after 3:45 p.m. on a weekday when Blaine indisputably also had access to it. Nor did Avery account for the fact that Mishicot School District had spring break from March 24, 2005 to March 30, 2005, meaning Blaine and Brendan and anyone they invited over also could have been in the home on weekdays during that time, and from April 7, 2006 to April 18, 2006, meaning Blaine at least also had access during those weekdays. And the footnote says academic calendars for all Wisconsin school districts for the dates in question can be found at, and then the website. Of the 128 searches listed, only 28 of them occurred between 7 a.m. and 3:45 p.m. on a weekday. Moreover, of those 28 searches, only 3 of them occurred before Ms. Halbach's murder, 2 at 8:14 a.m. on Tuesday, September 13, and 1 at 7:54 a.m. on Thursday, September 15. Even accepting Avery's unsupported speculation that Bobby was the only person who could have conducted searches during that time frame, Avery failed to explain how Bobby Dassey's only possibly having searched for pornography a mere 3 times before Ms. Halbach's murder is sufficient to show he was a voracious, violent pornography consumer on October 31, 2005, who was thus spontaneously motivated to abduct and kill a stranger on site that day because of it. Again, tell me why Stephen would do it. Avery now claims this was an erroneous finding by the circuit court because several searches took place on September 18, 2005, which is uncontested. That lends no support to his contention that Bobby was the only person who could have conducted them. However, because September 18, 2005 was a Sunday, the entire family and any guests they had would have been available to perform them. Moreover, to support this contention, Avery points only to his inadmissible police procedure expert, Greg McCrary's belatedly offered unqualified opinion that Bobby made the September 18, 2005 searches and that they were evidence of sexual paraphilia. Avery offered not one shred of factual support for McCrary's statement, nor anything showing McCrary has the relevant credentials to offer it. Indeed, he still fails to point this court to any evidence he submitted to support that statement. Avery failed to support his allegations in his motion with sufficient factual particularity to establish anything related to Bobby Dassey or even to a crime. There were no timestamps given for the searches Avery pointed to in Detective Velli's report, and no explanation of how any of them are relevant to any individual's motive for this murder. Most of them are generic and mundane. The mere fact that someone searched for news, body, journal, and cement doesn't show anything similar or related to this crime. Avery failed to provide any facts that connect even the actual pornography searches to anything that occurred here. Someone searching for ghetto sluts has no relevance to this crime whatsoever. As this court previously observed, despite Avery's insistence that this pornography is similar to what happened to Ms. Halbach in this case, quote, there is no support for this conclusion in the evidence on record, unquote. There remains none. I will again say, if they found ghetto sluts on Stephen's computer, they would have tied that to him killing Teresa. Avery once again attempts to rest his theory on Dressler versus McDaughtry, as if it held that any and all pornography consumption establishes a motive for murder regardless of circumstances. And now it's going into Dressler, and I'm not reading Dressler. This page is more on Dressler. Okay. Here, however, the searches Avery attempts to rely on vary widely from the obscene to the mundane, with no relation to how Ms. Halbach's murder occurred. Indeed, Avery failed to point to a single image or search for someone who was shot and the body burned, nor anything that would suggest that these widely varying types of pornography had any similarity whatsoever to Ms. Halbach's murder, and he relied on such irrelevant and off-point searches as MySpace, tires, race car accidents, Ford Tempo car accident, diseased girls, and big woman naked. Additionally, in Dressler, there was no dispute that Dressler, blah, 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 more Dressler stuff. Here, the material on which Avery relied and actually provided some timestamps for had no similarity or relation to how Ms. Halbach's murder occurred, which nobody knows how it occurred. And the vast majority were not made until months after is italicized, the murder. Avery fails to explain how a motive to fulfill a murderous, porn-fueled sexual fantasy can be formed or proven by someone not seeking or viewing any of this non-similar material until months after the murder had already occurred. To the extent that Dressler is relevant at all, it shows that Avery did not meet his pleading burden because a comparison to it shows these computer contents would not be admissible to prove motive if Bobby were the defendant. Other acts evidence is admissible if it meets the familiar three-part test from State versus Sullivan, requiring it to be offered for permissible purpose, relevant, and that its probative value is not outweighed by unfair prejudice. The latter two prongs are not met. Motive is a permissible purpose for introducing other acts evidence, but as explained, none of what Avery presented is relevant to show motive to commit this particular crime. This court already determined that Avery's contention that these images are similar to the murder of Ms. Halbach was false. The pornography and videos of murder and mutilation deemed relevant in Dressler were indisputably Dressler's. And now talking about Dressler case, blah, 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 blah. Nothing about an unidentified person searching a communal computer for various types of pornography and pictures of race car accidents or drowning victims months after Ms. Halbach's murder occurred shows an interest in anything similar to this crime, nor makes it any more or less likely that Bobby Dassey, or anyone else for that matter, had a motive to shoot, or anyone else for that matter, including Stephen, to shoot and kill Ms. Halbach in October 2005. The computer contents are simply not relevant. These searches and images would be excluded as other acts evidence because without some closer tie to the events of October 31, 2005, their prejudicial value would greatly outweigh whatever minimal relevance they might have and influence the jury to convict because they believed whomever conducted the distasteful searches must be a bad person. Avery's claim that the circuit court, quote, ignored Mr. Avery's evidence of Dassey computer deletions, which infers consciousness of guilt, unquote, similarly rests on no foundation. Avery offered nothing showing how or who made any deletions or why they mattered. He again simply relied on his unfounded claims that this pornography closely resembled this crime, which this court previously found, quote, wholly strayed from the facts, unquote, and an unsupported contention that Bobby Dassey was responsible for deleting it. Avery's insistence that these deletions were made by Bobby and show consciousness of guilt is, as usual, no more than unsupported guesswork grounded in presuming the conclusion Avery provided no facts to prove. That law enforcement were seeking evidence of motive, among other things, in their search warrant affidavit cannot carry the load Avery assigns it either. Police seizing and analyzing the computer seeking evidence of motive does not mean that anything they found ipso facto is, the word is italicized, is evidence of motive, as Avery appears to believe. Law enforcement investigating a murder search for anything that could conceivably be relevant to the case, vast portions of what the police collect is later determined to be of no importance. Avery's contention that law enforcement's reporting about this pornography means the pornography's mere existence establishes that Bobby had a motive to commit this crime is pure speculation, which Avery did not factually connect to Bobby or show has any similarity to this crime with any evidence at all. Now we're on page 23 of 42, and I agree, Gail. It is not the state's burden on Avery's third collateral motion to eliminate Bobby as the individual who made the searches, nor to definitively disprove any of the rest of Avery's specious conjecture. It is Avery's burden to provide facts in his motion showing that he could prove at a hearing that Bobby was responsible for these searches and that they would actually establish a motive for this murder. With no facts pled that could establish that. 1. Bobby conducted these searches and viewed this pornography. 2. That it was at all relevant, let alone similar to what happened to the victim in this case. And 3. That they were conducted before the murder occurred. The circuit court was correct that Avery failed to approach the threshold of making a plausible, factually supported motive argument. And the footnote says, as the state will explain, Avery utterly failed to prove opportunity as required by Wilson, and his purportedly, quote, powerful direct connection evidence, unquote, amounts to no evidence at all. They thus do nothing to affect the evaluation of his alleged motive evidence. Additionally, Avery's throwaway supposition that Sawinski's allegations, quote, offers evidence that the motive could have been a robbery, unquote, was not presented to the circuit court and is therefore forfeited. All right, back up. Where was that footnote? Sorry, I have to find where I was. Where the heck is that footnote? Pause. I cannot find where that footnote is. There it is. Oh my God. It's at the end. I don't know if you could see it. It's at the end. So in my eyes, it was making it look like it was like quotes. So I wasn't seeing that 10 there. All right. Next section 3 is titled The Circuit Court Properly Found That Avery Failed to Plead Facts Showing That Bobby Dassey Had the Opportunity to Commit This Crime or Stage This Scene. quote, the second prong of the legitimate tendency test asks whether the alleged third-party perpetrator, and now this is italicized, could have committed the crime in question, unquote. Evaluation of this prong is guided by the defense's theory that the third party's involvement of, I don't know why my mouth is not working today, involvement in the crime. I had one permanent crown and one temporary crown put in last week. Maybe that's why. Sometimes opportunity can be established by simply showing the third party was at the crime scene. When, as here, the theory of how the third party committed the crime requires that person to have carried out a series of complicated and difficult tasks, it is not enough to show the third party's mere presence at the scene and an unaccounted for period of time. In this situation, to meet the opportunity prong, the defendant has to offer evidence that the alleged third-party perpetrator had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in the manner the defendant alleges. In other words, quote, evidence that the third party had the realistic ability to engineer such a scenario, end quote. The circuit court appropriately concluded that Avery's submissions did not meet this threshold. Avery claims that, quote, the opportunity element has already been decided, unquote, because pre-trial in 2007, the circuit court found opportunity by virtue of Bobby's presence on the property. But that fails to acknowledge that Avery's defense theory has changed drastically from the time of trial. Then his contention was that he was framed by law enforcement, who had plenty of time, knowledge, and access to the evidence to plausibly doctor the crime scene to meet the opportunity prong then. He only had to show that, to meet the opportunity prong then, he only had to show that the alleged third-party perpetrator had the opportunity to, now this is italicized, kill the victim. Because his theory was that the police framed him. Now he claims his nephew Bobby Dassey planted all of the evidence against him and did so in a very short time period. That means to sufficiently plead his motion on opportunity, he had to provide more than just a showing that Bobby was physically present and had access to the evidence. He had to provide facts showing that Bobby had the, quote, realistic ability to engineer such a scenario, unquote, meaning a realistic ability to both commit the murder and then complete each step of this framing process, and to do so before November 5. And Avery did not provide facts that would establish at least 4 key components necessary to sufficiently plead that Bobby had the opportunity to kill the victim and plant all the evidence against Avery: the why, the when, the where, and the how. All right, I'm not a lawyer, and I don't say I'm basically a lawyer or pretend to be a lawyer. Why would you put everything in a filing? These things are long enough as it is. So you would think you would only put basic stuff in a filing, and then you're trying to get to some kind of a hearing where now you will go more in depth on things. That's just my opinion. And then saying that he said this about law enforcement, now saying this about Bobby, I don't see the problem with that. As facts and evidence change, you go in a different direction. And also saying that law enforcement did this and now saying Bobby did this does not mean it wasn't law enforcement. You're showing reasonable doubt. You're showing that there's possible other avenues other than Stephen to have done this. Assuming for the sake of argument that Avery had pled facts that would establish Bobby's motive to kill in the first place, and then in parenthesis it says, and as explained, he did not. But again, why do you have to prove Bobby's motive, but there's no motive for why Stephen would do this? There's no motive. There's nothing in his history that would say he would kill a woman. Don't tell me about the cat. Him being there when other people killed a cat doesn't mean he would kill a person. How many animals has Bobby Dassey killed? So if you're going to say being there when somebody kills a cat equals he would kill a person, then what does that say about Bobby Dassey and all the deer and whatever else he's killed? Barb, how many has she killed? Scott Taddock, how many has he killed? Earl, Chuck, Raleigh Johnson, all these people who we like to pew pew, shoot our guns, and we're going to shoot at varmints. Must mean they've killed people, right? Avery did not offer anything that would suggest why is in italicized, Bobby would want to frame Avery. Yeah, there was. Especially given the grave risks and extreme difficulty of doing so. Why would Bobby frame Stephen? Because he killed somebody, and the easiest way for him to remain free is to frame his uncle who lives on the same property that is already embroiled in a $36 million lawsuit against the county. And an uncle who he hated because Bobby was stealing car parts and selling them, and he was stealing drugs out of the pit. And so Stephen would argue with Bobby and argue with Bob about things that Bobby did. So this was brilliant for Bobby of, I kill this chick and I get rid of Stephen who's causing me trouble here. Oh, Gail. Anyone who murders someone typically wants to escape detection, but that does not explain, now this is italicized, why Bobby would frame Avery for it, especially when doing so would ensure that law enforcement would be taking an intense look at the entire property and everyone who lived on it. They did not take an intense look at anybody and Avery Salvage other than Bobby. Stephen. So initially, Bobby put the car at the turnaround. That multiple people saw that car parked at the turnaround. And that wasn't getting anywhere. So then Bobby moved it back when all of the family was going to Crivets. He offered no reason why Bobby would want to send him to prison. Does he have to offer a reason? And again, you put generic in a filing and then get to the hearing, and we can go into why Bobby wanted Stephen in prison and why I was told specifically by a family member that they all wanted to be rid of Stephen. Nor has Avery explained why someone who wanted to frame him would go to such lengths to hide, the word hide is italicized, the evidence. Surely if Bobby or anyone else wanted to frame Avery, they wouldn't have gone out of their way to make all of the evidence difficult for law enforcement to detect, gather, and connect to Avery. It makes no sense to burn the victim's remains and personal property in an attempt to conceal them or to drip Avery's blood around the RAV4, but then remove the license plate from and attempt to hide the vehicle by covering it with debris far away from Avery's trailer. Avery provided no facts explaining why Bobby Dassey's framing him is plausible when he is given no reason whatsoever explaining why Bobby would do this. All right, I just need to go back to this for a second. So Bobby moved the RAV4 back to the salvage yard, and early morning of the day that some family was already in Crivets and some were going to be going to Crivets early that Saturday morning. Where it was parked at Avery Salvage is not anywhere that the people who actually ran the salvage yard would have parked it. Because while it's just a junkyard to you and I, where there's no rhyme or reason to it, they would park all these cars that are this here and all these cars that are that there. So this car was in the wrong spot where other cars that are like that. Now, by like that, I'm not saying blue or green RAV4s. It might be, this year SUVs or whatever you want to call it. But it's in the wrong spot. It's double parked and going the opposite direction of everything else. And nothing else that's parked in that section has anything on top of it. So putting things leaning up against it on top of it makes it stick out like a sore dick. So that's why you would cover it that way, because you want it found there. You're not going to park it in Steven's driveway because you want it to look like he was trying to hide it. And I will say this for Bobby Dassey. While many in the Avery family are low IQ, Bobby is not one of them. He had, so he's not a complete imbecile. So if he's going to frame Steven, you're not going to just pull it in his driveway. Burning her items. He burned some in his own burn barrel. Oh, I just saw Diana saying, you guys cherry pick info. Who are you referring to, Diana? Because if you are a guilter, poof, you'll be gone. Waiting to see if you want to explain yourself or if I just need to boot you. I don't know if Christopher is here right now. And if you're saying I cherry pick info, no, I go by the facts, not cherry picking anything. The facts are the facts. Let me go back to, I was on this page. I was just on there to remind me of what I wanted to say on those things. More importantly, Avery's pause. Bye, Diana. Okay. Hold on, sorry. Okay. More importantly, Avery's argument fundamentally failed on the when and the how Bobby could have committed the murder or planted any of the evidence. He provided nothing that could plausibly establish that Bobby had the knowledge, skills, tools, or time to engineer this elaborate ruse. The mere fact that Bobby was on the Avery property at some time when Avery's hand was bleeding falls far short of facts necessary to establish that Bobby had the opportunity to successfully orchestrate this extremely complicated supposed frame-up. That's complicated? The complete absence of the necessary facts to support several crucial elements of how Bobby could have accomplished staging this scene demonstrate. Hey, Corey. Thank you, Corey. sorry, demonstrate that Avery failed to plead sufficient facts to show that Bobby had any opportunity to kill the victim and frame Avery in this manner. Avery offered no facts at all in his motion that would establish how is italicized, Bobby Dassey, an 18-year-old high school graduate with no criminal record whatsoever and who was working third shift at a furniture factory. 1. Managed to steal at some unidentified time prior to October 31 the rifle hanging above Avery's bed with which the victim was shot, and at some other unidentified time before November 5 managed to replace it with Avery's never noticing. Okay, let me address that point as we go. There is no proof that Raleigh Johnson's rifle that was hanging above the bed in Raleigh Johnson's trailer that Stephen was renting shot Teresa Halbach. There is a casing that was found on the floor of the garage that matched that rifle, that had something red on it that Kathleen Zellner showed in Making a Murderer Part 2, whatever you want to call it. Could be the paint of shooting into the garage that Raleigh testified he did on the regular. And it had a wax-like substance on it. And Manitowoc or whoever had collected things from Teresa Halbach's home, including her chapstick and her toothbrush, and they brought it to Avery Salvage Yard. For what reason? I'm going to have to find that again, or if somebody else has that on the ready, send it to me. But I was flabbergasted years ago when I saw that they collected evidence from Teresa's home and brought it to the salvage yard. For what reason? So in year one, saying the rifle hanging above Avery's bed with which the victim was shot, there's no proof that she was shot with that rifle. They only have a casing found on the garage that was shot by that rifle that they're claiming has Teresa's DNA on it. Thank you, Kathy. And also, let me also point out that 22, not a gun person, but my husband is. And so that 22 is very common. Bobby Dassey had one. Barb Toddock had one. And Bobby Dassey had one that then Scott Toddock was trying to sell at his work right after the crime. All right. Point 2. Could have abducted and killed the victim and hidden both her body and her car in some unspecified area in the minutes between her arrival on the property and Scott Toddock passing Bobby Dassey on the highway around 3 p.m. on October 31, 2005. Nor did Avery provide any facts to establish where the killing could have happened apart from a nondescript in the RAV4 or where Bobby could have hidden the RAV4 and the victim's remains in this short period of time. Scott Toddock and Bobby Dassey both lied. Don't know if they saw each other at 3 p.m. passing like that. Don't know. There's no proof to it other than what they're claiming. 3. Had the scientific sophistication and knowledge necessary for it to occur to Bobby to collect, transport, and plant Avery's blood from his sink, and, as Avery completely overlooked in his motion, his non-blood touch DNA on the hood latch of victim's RAV4 and her keys, or how Bobby acquired the skills and knowledge to do this successfully. Well, but why don't you let a jury decide that? Why is it up to you to say Bobby didn't have this? 4. Had a convenient stash of unidentified instruments capable of collecting and transporting liquid blood and touch DNA on hand, or what those might have been. He took a Q-tip. If it was this is the only place that I do not agree with Kathleen Zellner. I do not think Bobby Dassey planted the stuff. I still feel law enforcement did that, or I'll just say law enforcement, Manitowoc. I believe they planted it. But it's taking a Q-tip, wetting it, wiping it, and then doing it. And the stuff that's like on the floor of the RAV4, those were blood flakes. It was not a drip of blood that would have sunken down into the carpet. It would look completely different than a flake that's resting at the top. 5. Planted the keys to the RAV4 in Avery's trailer unnoticed and at some unspecified time between November 3 and November 5, yet also either managed to move the RAV4 off of the 40-acre property without the keys or drive it away and return on foot from wherever he supposedly took it, and then sneak into Avery's trailer again to hide the keys at some other unidentified time, once again unnoticed. Footnote. This is also completely inconsistent with Avery's allegation that Baresh saw Bobby driving what Avery contends was the victim's RAV4 in the morning hours of November 5, and Avery did not attempt to explain at any point when or how Bobby could have planted the key in his home if Baresh's information were true. All right, so let me comment on that. Good night, Elaine. Because it's the valet key. The ignition key is missing. So you could hide the valet key and still drive the car because the engine key is gone. The valet key is not a key that you use. And the fob is gone too. So that's pretty simple. There's 2 keys. That was just the valet key. 6. Found and then planted a tiny mangled bullet fragment that Bobby inexplicably knew had the victim's DNA on it underneath items in Avery's garage, or alternatively, how he shot the victim in Avery's garage on October 31, and then at another unidentified time scrubbed the scene with Avery remaining unaware, this despite Avery indisputably having been working on his Suzuki and other vehicles in and around the garage around this time. Bobby didn't do anything with the bullet fragment. This again, I believe, planted by Manitowoc, not Bobby. And even if you're somebody who's planting this, you don't have to find the bullet she was shot with, because you're just picking up one of the bazillions of casings that are laying around, and you wipe Teresa's chapstick on it, and there you go. And I want to know why, when they find this magic bullet, was it 5 months later? There's no dust on it, but there's dust everywhere in the garage. 7. Burn the victim's body in some undisclosed location and then move the remains to Avery's burn pit, again completely undetected, and did so thoroughly as to include, quote, at least a fragment or more of almost every bone below the neck, unquote, in the entire human skeleton, along with the rivets from her jeans. Nor did Avery provide any facts showing where and when this occurred. It's not an undisclosed location. It is the Manitowoc gravel pit. right? And that's where bones were found that Mr. Sweaty Sweat Ken Kratz, these aren't the bones you're looking for, said that Teresa never left Avery Savage. And he wasn't going to talk about those bones that were found there. We don't even know if those bones are human, he said. Yet years after the trial, when it is law that you have to keep the evidence in evidence unless the person who is in prison gives their permission, that stuff remains in evidence because science is changing, right? And it's been agreed upon between the state and the defense that they want to test these bones. Oopsie, they gave them to the Halbach family. Why are you giving bones that you are saying is not Teresa Halbach's to the Avery family? Karen Halbach signed for it when they were delivered. Why did you give those bones to them, to the Avery family, if there's no proof that she was burned anywhere else? When they've been asked, why would you give these bones to the Halbach family, they say, well, for closure. How is that closure if that's not Teresa? That she never left Avery Salvage and she was burned behind his garage. Oh, yeah, whatever. 8. Convinced his younger brother Brendan to go along with this plan and fabricate a confession implicating not only Avery but also himself, italicized, or why Brendan would do so. Brendan is not involved in this whatsoever, and Brendan is innocent. He was coerced into a false confession by Wiegert and Leigert, or Fackbender and Leigert. So Brendan's not going along with any killing of anyone. It is not possible. So why would Stephen have to prove anything about that? Because Brendan is innocent. Even if one accepts at face value Avery's theory that Bobby was scientifically sophisticated and equipped enough for it to occur to him to do all this blood evidence gathering and planting, Avery provided nothing that would explain how Bobby would have done so in the roughly half an hour before the blood would have coagulated or dried while Avery was at Menards on November 3. And Avery did not plead even a single fact to establish how or when Bobby could have planted any of the rest of the mountain of forensic evidence against Avery, particularly the victim's remains, which say consistent with the maternal line of Teresa's family. The non-blood DNA evidence. Oh, is that what you're calling the sweat DNA now? Is the non-blood DNA evidence? The sweaty sweat DNA that came off of his gloved hands, so he doesn't leave a single fingerprint, but leaves his sweat and his blood everywhere. And the bullet. And also successfully eliminate from the scene any trace of his own involvement or physical presence. We're on page 29 of 42. In sum, Avery provided no facts in his motion that would establish why Bobby would want to frame him, or when, where, or how Bobby could have even possibly accomplished any of the necessary tasks to make this theory plausible. He supplied nothing other than a series of constantly shifting affidavits about his and others' activities during the relevant time frame, and then backfilled it with speculation, with zero factual support, about how a small fraction of the evidence against him, the blood and the car only, could have ended up where it was if someone else was the perpetrator and pretended the rest of the evidence does not exist. That is flatly insufficient to provide facts that could show that Bobby had the opportunity to engineer this complicated scheme. Avery has attempted to cure this failure on appeal by offering up his previous statements about what his experts purportedly found regarding the physical evidence, which this court already rejected as misleading and irrelevant speculation. Pause. Is it this court? This is a new judge, right? So it might be the same level court, but it's not the same judge. So this judge didn't say this. Avery did not provide these theories to the circuit court. They couldn't form the basis for relief now, even if they had some substance. Regardless, inaccurate statements and speculation do not even show possibility. Avery further misses the point when he contends he was, quote, less qualified to commit the murder than Bobby, unquote, because he had less education and never held a job. Obviously, no qualifications are required to commit murder. But if Avery wants to contend a specific person committed this, italicized, this murder, and now this is italicized, then framed him for it, he has to provide facts plausibly showing that the person was actually capable of doing so and also capable of staging all of the evidence. He did not come close. Well, let's get a hearing, and we'll show you all of that. Avery has abandoned all argument that he can meet Wilson's requirement and instead tries to distinguish it because it was not a case about someone alleging being framed. That is irrelevant. The Wisconsin Supreme Court made crystal clear in Wilson that it is the defense's theory of the third party's involvement that dictates what must be shown to establish opportunity, and when that requires the third party to perform a series of complicated tasks, the defendant has to show that the third party realistically has the skills, tools, time, and ability to do so. This is because, quote, Denny's is italicized, Denny's legitimate tendency test requires more than mere possibility, unquote, that another person committed the crime. Nor does State versus Volbrecht assist Avery. And now they're talking about the Volbrecht crime. Blah, blah, blah. I'm not reading all of that. I really hate that you have to find other cases like yours because every case is different. Okay, that is nothing at all like what Avery attempts here. His motive evidence totals 3 possible searches for pornography predating the murder that he cannot even actually connect to Bobby Dassey and that have no relation to the manner in which this homicide occurred. Avery provided only wildly implausible conjecture with no facts showing that Bobby had the knowledge, tools, time, or ability to commit the crime and stage the evidence, most of which he wholly ignored and did not account for. Whereas in Volbrecht, there was no special scenario that had to be achieved. The perpetrator simply needed the time to kill the victim. And as the state will explain below, Avery provided 0 facts directly connecting Bobby Dassey to the actual killing or even to the victim's vehicle. Whereas in Volbrecht, we don't care about Volbrecht, blah, blah, blah. Volbrecht does not assist Avery in the least. State versus Knapp is similarly inapposite. There, the victim was beaten to death. We're not reading another case again. Here, Bobby's mere presence on the Avery property and 2 vague affidavits, contending he had a RAV4 5 days after the victim's murder, do nothing to establish any fact showing he could have actually accomplished committing this murder and planting all of the evidence in this case. The circuit court correctly determined that Avery did not plead facts in his motion and could establish Bobby's opportunity to commit this crime and stage this scene. Let me again say where they're saying, where is the wording now? Where was the word? Vague. it was vague affidavits, right? That's what they said there. Yes, 2 vague affidavits. Let me again point out that these 2 people came forward before making a murderer. And Sawinski came forward before she was even found. So, I mean, come on now. Section 4. The Circuit Court properly found that Avery did not plead sufficient facts or any facts directly connecting Bobby Dassey to the perpetration of the murder. Direct connection is assessed by considering, quote, the proffered evidence in conjunction with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third-party perpetrator, now this is italicized, actually committed the crime, unquote. And take the defendant's theory, quote, beyond mere speculation, unquote. Quote, no bright lines can be drawn as to what constitutes a third party's direct connection to a crime, unquote. But it must be more than, quote, a connection between the third party and the crime, unquote. It requires, quote, some direct connection between the third party and perpetration of, that's italicized, of the crime, unquote. Avery claimed that he met the direct connection prong because Sawinski claimed to have seen Bobby Dassey pushing a RAV4 on November 5, 2005. He's wrong. Sawinski's averments that he purportedly saw Bobby and someone else pushing a RAV4 on November 5, several days after Ms. Halbach's murder. You don't know what day she was murdered, if she was murdered. Do not provide a link between Bobby Dassey and... Now this is italicized, perpetration of the murder, nor any factual link between Bobby Dassey and any of the forensic evidence. At the most generous, the affidavits Avery submitted could establish that Bobby was involved in moving the RAV4 to the location where it was eventually found. That is nothing more than a possible, quote, connection between the third party and the crime, unquote. It provides no link at all between Bobby and the perpetration of the actual killing. And given that Sawinski and Baruch aver that they saw two is italicized, 2 people, it doesn't even connect Bobby to the crime because he wasn't in exclusive possession of whatever vehicle they saw. It also provides no connection between Bobby and any of the physical evidence, as the circuit court observed. Avery's contention that this purported sighting of Bobby pushing a vehicle means Bobby was in possession of the victim's car key and electronics is nothing more than, quote, speculation by the defendant, unquote. Sawinski never says he saw Bobby with any keys or electronics or any other of the victim's effects. In fact, that Sawinski says these individuals were pushing the vehicle suggests that they were not as italicized, in possession of the keys. Meanwhile, Baruch says he saw Bobby driving the car the same night, meaning Avery's purported evidence is contradictory, and he provided no facts showing how Bobby could have planted the victim's car keys in Avery's trailer in either scenario. All right, so let me go back to what I just read here. So Bobby being your star witness, saying that the last he saw of Teresa Halbach, she was walking to Stephen's trailer, and then having a witness that saw Bobby pushing her car onto Avery Salvage, not away from Avery Salvage, onto Avery Salvage. Doesn't throw reasonable doubt. And he's pushing it because it was what time in the morning? And Dolores and Stephen were not in Crivets yet. They were driving there later that morning. And so you're taking that vehicle not far from Dolores's trailer. So you would be pushing it, hoping nobody would hear that slow-moving car. Sawinski doesn't need to see Bobby holding keys or the electronics to not make it look suspicious as fuck that Bobby and somebody else that is not Steven is pushing a missing person's vehicle to Avery Salvage. That makes no sense on why Bobby would be pushing it to Avery Salvage if he didn't commit it but was helping somebody else in covering up. Why would it go back to Avery Salvage? That makes zero sense. Sawinski and Baruch's affidavits also do nothing to establish that Avery was not the killer. Even if believed, all Sawinski's evidence would show is that perhaps Bobby was involved in trying to cover up Avery's crime. And then they want you to look at the Bembenek case. That is far and away the most natural interpretation of the information imported by Sawinski and Baruch when considering, in light of the existing evidence, even assuming both that their statements are accurate and that the car Bobby was seen with was the victim's. After all, Avery recruited Brendan to help him try to cover his tracks. Prove that. Without Brendan's coerced false confession, prove that Brendan was recruited for anything. The same could be true about Bobby. Direct connection requires a showing that, quote, under the totality of the circumstances, the evidence suggests that a third-party perpetrator, now in italics, actually committed the crime, unquote. Nothing Sawinski or Baruch ever connects Bobby to the actual killing in any way. So what connects Steven to the actual killing? What connects Steven to the killing? That is Raleigh Johnson's trailer. That is Raleigh Johnson's gun. It is Raleigh Johnson's casings. It is Raleigh Johnson's burn barrel. It is Raleigh Johnson's burn pit. What was found in the Dassey burn barrels? So, other than Brendan's coerced confession, what evidence is there that Steven committed this? Her key being in his bedroom? That doesn't mean he committed a crime. He could have found that key laying in a salvage yard and picked it up and put it in his bookcase. His blood being in the car, maybe he doesn't remember that Bobby did something else with the car first, and Steven thought it was a car that was now there at the salvage yard that he went into. And he got blood in there. I mean, I could come up with all kinds of wacky tinfoil hat things, but there is no direct evidence to say that Steven committed this. Baruch's claims are even more generic and speculative than Sawinski's. They do not provide a description of the vehicle he purportedly saw, just that he saw, quote, a RAV4 driving south on County Road Q, quote, again 5 days after the murder. That establishes nothing suggesting whomever was in this car killed the victim. It doesn't even plausibly establish that the victim's RAV4 is the car he saw. He gives a vague description of seeing news about the trial in 2006 or 2007 and says that's how he somehow recognized Bobby as the driver a year later. But Avery provided nothing showing that Bobby was ever on any news reports during that time. And yet Baruch cannot describe the other passenger at all. beyond somehow being, quote, 100% sure it was not Steven Avery. Though he says he knows none of the Avery or Dassey family members. All right. So let me go back to this. We see on Making a Murderer Bobby all the time in court. We see him outside talking with Fackbender. You're telling me those scenes were never on the news? So, prove that Bobby Dassey was never on the news for Baresh to have seen to recognize him. Was there something else I wanted? Oh, but the other thing I said is, wanted to say was, Bobby's own brother Blaine said he saw Bobby driving the RAV4. I know nobody's talking about that, but I'm talking about that. Oh wait, I'm still on this side. As the circuit court aptly observed, quote, the defendant's conclusory assumptions drawn from the evidence offered in the affidavits do not amount to evidence directly linking Bobby to the homicide itself, unquote. Particularly when coupled with Avery's utter lack of facts establishing Bobby's motive or opportunity and nothing tying him to even a single piece of the forensic evidence, Sawinski's and Baresh's averments amount to nothing. They do not even state facts that would establish that whomever they saw was actually in possession of the victim's car. It was not the only RAV4 in existence. Avery's multiple layers of conjecture piled on top of an allegation that Sawinski maybe saw Bobby and a second person pushing a car similar to the victim's at some point, while Baresh contrarily claims he saw two people driving one, do nothing to establish any fact showing a legitimate tendency that Bobby actually murdered the victim. Well, two can play that game. Was Teresa the only one that had that Palm Pilot and that phone? And where's her camera? She didn't go anywhere without her camera. She's a photographer. Where's her camera? So how many people shop at Kohl's? So just because you find Daisy Fuentes jeans rivets, prove those were Teresa's. You can't prove just because one of her little sisters claim that those Daisy Fuentes jeans were not at Teresa's house, that means those were Teresa's, and that her jeans weren't left somewhere that she had spent the night and wore something else. She spent the night other places all the time. That's one of the reasons Scott Blodorn claims that she was missing for days and he didn't know it, because she would go sleep at people's houses. So prove that those are her Daisy Fuentes rivets. Prove that's her Palm Pilot. Prove that's her phone. Where is her camera? State versus Williams, upon which Avery attempts to rely and has failed to provide in correct citation format, identifying it as an unpublished opinion, predates July 1, 2009 and is not citable. And the footnote says, this is, at minimum, opposing counsel's 10th violation of the rules of this court. And that does not include the numerous misrepresentations of the law and the facts. Ooh, I can't wait to see what Kathleen has to say about that. The state does not discuss it further. In short, the tendency that Bobby committed this crime based on what Avery has presented here has not even entered the ballpark of legitimate. The state does not dispute, quote, that facts give meaning to other facts, unquote, but that requires Avery to have provided some actual facts on all three prongs of Denny to begin with. Avery's allegations are conjecture and speculation plugged into accounted for periods of time of Bobby's time. That is, and always has been, insufficient to meet Denny. The dearth of facts in Avery's motion necessary to establish Bobby's motive or opportunity to commit this crime and then carry out this elaborate planting scheme, along with nothing tying Bobby to perpetration of the actual killing or any of the forensic evidence, means Avery has failed to establish a, and this is italicized, legitimate tendency that Bobby was the killer. Avery thus failed to meet his pleading burden on his newly discovered evidence claim. No hearing is necessary. Section D. Even if Avery could have met the three prongs of Denny, there is no reasonable probability that presenting Avery's new defense would change the result of the trial. If the newly discovered evidence presented by a defendant would be inadmissible at a new trial, there is no way it could impact the jury's evaluation of the other evidence, and the defendant fails to meet his burden. Avery's latest attempt at a Denny is italicized, defense would not be admissible, meaning there is no probability of a different result at a new trial based on it, meaning we just want to hide it. Quote, the Denny, italicized, test is a three-pronged test. It never becomes a one- or two-pronged test, unquote. If a defendant fails to make an adequate showing on any of the prongs, the third-party perpetrator evidence is inadmissible. Avery failed to meet his burden on all three prongs of the test. He failed to connect Bobby to the pornography or the pornography to the crime for motive. His opportunity evidence is flatly insufficient to establish that Bobby could have committed the crime or staged the crime scene. And his direct connection evidence doesn't establish a connection between Bobby and the actual killing. Accordingly, no jury would ever be presented with what Avery has submitted here, and therefore there is no possibility that it would affect the outcome of a new trial. Even assuming that Avery's new witness testimony was sufficient to meet Denny, italicized, and Avery had a new trial presenting this defense instead of the police bias defense, though, there is still no possibility that any jury hearing it would have a reasonable doubt about Avery's guilt. Okay. Accordingly, he could not meet the final requirement for asserting a newly discovered evidence claim. As explained above, there are far too many irreconcilable inconsistencies between Avery's allegations about Bobby Dassey and the actual evidence produced at trial. Particularly fatal would be Avery's complete failure to account for his DNA on the hood latch of the RAV4 and Ms. Halbach's remains, again, including a fragment from, quote, virtually every, unquote, bone in the human body being found in his burn pit, and nothing to explain how Bobby could possibly be responsible for the bullet with Ms. Halbach's DNA on it being found in his garage and matched to the gun above his bed. Let me again talk about the sweaty sweat on the hood latch that they're now just saying DNA. They're not saying sweat DNA, since they know now that's not a real thing. So it has been said they could have transferred that by using Stephen's slippers. And I also know from somewhere at some time in the years that I have covered this case, need to look for it, is a lab tech said they had both cars in the garage, not both RAV4s. I don't believe there were two RAV4s. They had the RAV4 and they had Stephen's Grand Am. The tech was in Stephen's Grand Am picking up things, and then he went to Teresa's hood latch and never changed his gloves. So you are now transferring Stephen's not sweat DNA onto the hood latch. Period. End of story. Oh no, their crime lab would never make a mistake like that, right, Sherry Culhane? Moreover, the state would negate whatever little credibility Sawinski and Barash had on the stand. It could easily impeach Sawinski with the glaring inconsistencies between his latest story and Sawinski's prior statements Avery submitted previously. The information Sawinski initially provided to counsel does not at all match what his affidavits now say about what or who he observed when he observed them, who he spoke to at the Manitowoc County Sheriff's Office, and what their response was. And in fact, Sawinski's original information to current defense counsel would have, in italicized, eliminated Bobby Dassey as a suspect because Bobby was at work during the time frame Sawinski gave. Sawinski's account changed drastically after somehow having his memory refreshed by counsel and her investigators, with no documentation that would show how this memory refreshment could have been achieved. And the second person he purportedly saw has never been identified, meaning Sawinski's information could not even actually point to Bobby as the perpetrator. Baresh's generic claims suffer similar failings, in particular his failure to explain why he did not bring this information to any of Avery's attorneys until nearly 20 years after the murder, and after Avery's latest attorney put up a $100,000 bounty for purported witnesses. All right, I have to go back. Okay. It's been explained why Sawinski's story changed, or recount of the event changed. He thought the Innocence Project was Stephen's attorneys. So that is who he reached out to first. So that's why the affidavit then was changed when it was realized that he did not contact Kathleen Zellner's office. And why are we not, again, these aren't the facts you're looking for. Why are you not talking about then that it's fact that Sawinski called on November 5th and that Manitowoc buried that phone message? Why is that not discussed here? So you want to try and wipe away any possibility of what Sawinski is saying is true, yet there's fact that he did report it and that they hid it from everyone. Stephen's original defense didn't have that. And that it's only Kathleen Zellner now, years later, who is able to find the actual calls. And sure, Sawinski didn't remember who it was that he talked to back in 2005 at Manitowoc Sheriff's Department. Whoops. But he did report it. You're dropping the lead. And how would Sawinski eliminate Bobby? Do you have proof he was at work at that time? You don't have proof that Bobby was at work at that time. Show me proof he was at work. His memory is refreshed, as they like to put in quotes, because he claimed he had talked to Stephen's attorneys, and Kathleen knows you didn't talk to me. So it doesn't prove that Bobby is eliminated. And then this $100,000 bullshit thing that's being offered. I hate that money is being offered because it is total bullshit. There is fine print on it that says that the real killer has to be prosecuted. So nobody who comes forward is ever going to get that money. So people should be coming forward because it's the right thing to do. And there's two innocent men in prison for something they didn't do. You shouldn't do it for the money. Avery's new defense would essentially be just asking the jury to ignore the evidence introduced against him. When presented with the common sense explanation that the evidence was located where it was because Avery shot and killed the victim after luring her to the property and unsuccessfully attempted to hide the evidence of his crime, versus Avery's attempt to paint the then teenage Bobby as a porn-obsessed, scientifically savvy, and extraordinarily stealthy criminal mastermind who inexplicably wanted to frame his uncle, no one would have a reasonable doubt about Avery's guilt. Okay, so what to say on that? Well, Bobby wasn't alone. We know we already had the crisscross him and Scott Taddock. Not saying Scott Taddock is a mental giant either. And then whoever was helping Bobby push the RAV4. So there's at least 2 other people who knew something about this and were helping Bobby. So, and these people, Scott Taddock and Mike Osmondson, are also hunters who like to kill things. Just saying. Quote, courts may permissibly find, as a matter of law, that no reasonable jury could determine that the third party perpetrated the crime in light of overwhelming evidence that he or she did not, unquote. Here, overwhelming evidence that Bobby did not commit this crime exists in the utter absence of any facts tying him to the actual killing or to even a single piece of the forensic evidence. Bobby has access to Stephen's garage. Bobby has access to Stephen's trailer. Bobby has access to Stephen's burn pit. Bobby has access to Stephen's burn barrels. So let's say it happened exactly like you're saying it happened. Bobby could have done all that. Bobby could have taken that gun that from hanging over Stephen's bed and shot Teresa Halbach with it in Stephen's garage. Amy, I never get the whole thing too, that why would he put her in her own car? Yeah. Jurors are instructed to use their common sense when reaching a verdict, that the arguments of the attorneys are not evidence, and that a trial is a search for the truth. Any reasonable juror being asked to search for the truth in this murder trial would reject Avery's absurd new defense without fail. Okay. I know I've already been on here almost 2 hours, but I have to go down this again. And this is something, if you've been a longtime follower of Steven Avery Project, you will have heard this story before. I served on a jury, not a murder trial. The man was charged with possession of an illegal narcotic with intent to deliver. I'll always remember that. A drug dealer was selling cocaine. He was making the deal at like a Denny's restaurant. It was a sting, an undercover thing, so this drug dealer was talking to cops every time on the phone, in the Denny's restaurant, all that. So we had audio recordings of the actual deal going down. And then when they did now the person's going to pay for this brick of cocaine. It was really weird too, because they passed this brick of cocaine around in the jury room for us to pick this up and whatever. When the deal now was going down, which was across the street from the Denny's in a grocery store parking lot, there were undercover cops that were stationed around the parking lot. And we, once again, we're hearing all the audio of this deal happening. We had to deliberate for, and now I don't remember this for sure, if it was 1 day and a half or 2 days and a half. First of all, the reason we were deliberating longer than necessary is because they buy you food. And there were people on that jury that wanted the cheap ass pizza that they bought for us. And then also the pay that you get is just per mile, whatever, how long it took you to travel to court. And this was 19, it had to be 1990 or 1991 that I served on this trial. And we had a person on the jury that was going or was saying not guilty. Why? Because the charge was possession of an illegal narcotic with the intent to distribute or deliver. The legal definition of the word possession means at that time, I don't know if you Google it now what it says, but you have complete control. And so this person said not guilty because there were undercover cops all around. And so if the drug dealer had decided, oh, something doesn't feel right, I'm going to leave here with my cocaine and not do this deal, he would have been stopped and arrested. So therefore, he doesn't have possession. So this is why I don't give a shit about a jury. I'm sorry. I've served a jury. Now, we did eventually, and this is because the person got beat down basically into voting guilty, even though they didn't think guilty. I was literally in that jury room hitting my forehead on the table and going, you are such a fucking idiot. Because the person was guilty. Everything was there. The person was guilty. But you're going to say not guilty because of the definition of possession, trying to say that person did not have possession. They had possession. It's in their hands. They're trying to sell it to somebody. Ridiculous. Another reason I don't care about juries. They don't get all the evidence. The lawyers do everything they can to suppress. So we get more facts than a jury does. Because we're able to get all the evidence that is covered up. Well, to an extent. We don't get to have what Manitowoc erases. What else did I want to address on that? Also, are you psychic? Nobody knows how a jury is going to rule on something. Some juries are stupid, like the jury in the O.J. Simpson case. O.J.'s guilty. So you never, no one can say they know how a jury is going to answer anything. You don't know. All right, Section E. Avery's claim that the circuit court's factual findings are unsupported by the evidence is false, and two mistakes the court made are immaterial. Finally, Avery takes issue with several bits of minutia that he contends the court got wrong about the record. He has misunderstood the record for most of them, and he fails to show that any of them matter. Avery's complaint that the circuit court once referenced Brian, in quotes, Brian Dassey instead of Bobby Dassey is trivial. That was plainly a typographical error by the court. And Brian is spelled incorrectly, too, from the Brian Dassey. Moreover, the circuit court was correct that only a very small number of the searches Avery claims only Bobby could have been responsible for took place before the murder occurred. As explained, the evidence Avery submitted showed only the 3 searches taking place between 7 a.m. and 3:45 p.m. on a weekday before the murder occurred. He now claims that it was error on the part of the circuit court to so find, but he points only to McCrary's affidavit referencing the September 18, 2005 searches as support, and that affidavit offers no actual evidence about who conducted the searches, nor showing that they're all related to this crime. And again, September 18, 2005 was a Sunday. Anyone could have performed those searches. Avery next claims there is no evidence that Ms. Halbach was murdered on October 31, 2005, and that the circuit court got that wrong. That is absurd. The vast wealth of evidence introduced at the 5-week jury trial at which he was convicted of committing this murder plainly shows otherwise. Prove she was killed on October 31st. Even if you're going to say Stephen Avery did it, prove he did it on the 31st. Prove it. There is zero proof, guilt or not. There is no proof that she was killed on October 31st. Finding her bones can't tell you what day that happened, if they were her bones, which I contend we don't know for sure if they are. Finding her car on November 5th does not mean she was killed on October 31. Her own family didn't know she was missing until November 3rd. How do you know she was killed on October 31st? Nobody knows, except for whoever did whatever to her. Next, Avery complains that the circuit court erred in stating that some of the victim's bones were found in his burn barrel. True, but immaterial. Ms. Halbach's electronics were found in Avery's burn barrel. Prove they were her electronics and not just the same kind of electronics. Her remains were found in multiple locations, but the primary site was Avery's burn pit, proved by the forensic anthropologist who found at least one fragment from nearly every bone in the human body within it, as the circuit court correctly observed. Why are there no pictures of the bones when they were found? And so many things happened in this case, and I tell you all the time that I forget stuff. And if anybody here remembers the story, please post it here. What did this anthropologist do wrong at one point on a case she claimed a woman killed her baby or something? She got something so unbelievably wrong, this Eisenberg chick. And I'm supposed to take whatever she says? Somebody look that up or tell me what it is that she did. But I just remember it was appalling, because also the way this mother got treated and accused of this was, I mean, it was horrid what happened to this person on this, what this bone expert had to say, that you couldn't even take pictures of the bones, and wanted to say, oh, Stephen's dog was scary, that was chained up. Scary dog. We can't take pictures of the bones. Pictures, or it didn't happen. The 40 to 60% of the bones comprising the complete skeleton to which Avery refers was the expert's testimony that about half the total skeleton was destroyed in the fire. In other words, parts is italicized, parts of each bone were destroyed, but parts of each remained. And the jury was not, quote, unconvinced that Ms. Halbach was burned by Mr. Avery in his burn pit because he was acquitted of mutilation of Ms. Halbach's body, unquote. A judgment of acquittal is not proof of innocence. Well, judgment of guilty is not proof of guilt. Given that the common definition of mutilate is, quote, to cut up or alter radically, unquote, and there's a footnote, it's from Merriam-Webster Dictionary, it is not surprising that the jury acquitted on this count. The state could not provide evidence of what state Ms. Halbach's remains were in when Avery put her body in the fire, because so little remained intact. That does not mean Avery did not burn Ms. Halbach's remains in his burn pit. What did I want to comment on that? Oh, him being acquitted on mutilating the body. This is another thing a juror has said, and if you were on the Stephen Avery jury, I would love to talk to you. It can be totally anonymous, and I would never say who you are that talked to me. Trust me, I've had people come forward that I will never give up those people. I have had people I have given to Kathleen Zellner. I have given witnesses to Kathleen Zellner. I am just a conduit. You know, if you're somebody who has tried to reach out to Kathleen Zellner and couldn't get her because, you know, she's busy or whatever, I have had people reach out to me, and then I was able to get that information to Kathleen. Um, I want to talk to the jurors and I want to talk to the bus driver. But you can contact me by messaging this page, Stephen Avery Project. You can email official Stephen Avery Project at gmail.com or justicewithjax at gmail.com. And I will keep you secret. I get people don't want to come forward publicly because of, look at what Manitowoc has done to Stephen, not once but twice. They acquitted on mutilation of a body because they had reasonable doubt. But the best that could happen on this would have been a hung jury, because you had Carl Wardman on that jury. You had, again, not one, but two people on Stephen's jury that were affiliated with the Manitowoc County Sheriff's Department. And Carl Wardman was a community service officer for the Manitowoc County Sheriff's Department, and his son was a deputy. And so the guy was being quite pushy and bullying in that jury room. And so there were jurors that thought, if we got this compromise of acquitting on this one, that like it would cause a mistrial. They thought it would throw red flags that something's not right with this jury. And it didn't work. Jurors, please come talk to me. Or just go directly to Kathleen Zellner. That's another thing I say. You don't have to come to me if you don't want to come to me. Go to Kathleen Zellner. You can go to KathleenTZellner.com. You click on, she's got her highly publicized cases, a page for each one. And for Stephen's case specifically, she has a phone number and an email that you can reach out. So go directly to Kathleen Zellner. You don't have to come to me if you don't want. Go there, please. There was no error in relying in part on Brendan Dassey's confession to reject Avery's purported Denny defense. The fact that Brendan both confessed and implicated Avery is part of the record, and Brendan was convicted of this crime regardless of the fact that he wasn't forensically linked to it. Don't you just want to cry when you hear Brendan's name? It is a fact Avery must account for to show a legitimate tendency Bobby committed the crime, no matter, oh my God, it's almost 8 o'clock. Oh no, yeah, no, it's just after 7 here. Whether the state introduced it at the last trial, footnote, the state would of course not be limited to the same litigation strategy or evidence at a new trial that the state introduced at the last one. And Avery failed to provide any facts explaining why or how Bobby Dassey could be responsible for Brendan's confession. There is no Brendan and Bobby. Stop trying to make fetch happen. Brendan's got nothing to do with anything. He was coerced into a false confession, period. Avery failed to show that the circuit court committed any factual errors about his failure to provide any actual evidence in his motion on the 3 prongs of Denny. And he fails to show how any of the purported errors of which he complains makes any difference to its finding that he did not meet them. The circuit court properly denied Avery's insufficiently pled motion without a hearing. Conclusion: this court should affirm the circuit court, dated this 15th day of April 2024. I just got a Google alert of an article on what I'm reading. April 2024. Respectfully submitted, Joshua Call, Attorney General of Wisconsin, electronically signed by Lisa F. Comfer, Assistant Attorney General. And that is the end of it. Oh my God, 110. I'm so sorry, Debbie. All right. So, summarize. Fuck you, state. So now Kathleen will get to respond to this. I don't know when we will hear Kathleen's response. If you get it, if you don't see any mention of it here on Stephen Avery Project and you find it, please send it my way. Thank you to the person who sent it to me today, because, I'm working during the day, and, I'm not on here searching for things. So, and it helps me if somebody gets it and sends it to me. So then, because I get home at 5 o'clock and go live at 5:15. So it's like I come home, I let my dogs out, I start up my computer to get everything running, and then I go live. So it's good if I have it already, that, I don't have to go searching for it and everything. So whenever Kathleen um, has her response, when we get it, I'll go live. It's typically going to be at 5:15 p.m. my time. So the time I went live today is when I go live on any weeknight due to work. So yeah, so we wait for that. I always have to do a disgusting plug for my book, Wrongfully Abused, Making an Advocate for Stephen Avery by Jax West. I self-published it on Amazon. This is about my history of the case until the time I published the book. Other things have happened since then. And then one last thing I want to bring up. If any of the people here, I know most of you don't want to hear about any other cases. I advocate for 2 other cases besides this one, for people here in Illinois. And Melissa Kaluzinski, I don't know what that noise was. Why is my computer starting to make weird noises? Melissa Kaluzinski is another case that I advocate for. And Kathleen Zellner is her attorney. And Kathleen is going to be filing for clemency for Melissa on April 24th. So it's right around the corner. And so Kathleen has requested people to send her a letter that is asking the governor to grant Melissa Kaluzinski clemency. So if you go to my Justice with Jax page, or even here on Stephen Avery Project, because I did share it, which I know gets me grief because people don't want to hear about other cases. But it is Kathleen Zellner that is Stephen's attorney. And so please send her. You can either mail her a letter, or it's an email. And so the email is listed on that graphic. So write a letter, send it to Kathleen by April 23rd. I want her to have these letters by the 23rd, since she's submitting them on the 24th. On that, Melissa Kaluzinski is wrongfully convicted. She was forced into a false confession, and let her go. Give her clemency. And I'm actually scheduled to visit Melissa next week. And this visit was already scheduled before I found out, so I am visiting Melissa either the day before or the day after the clemency is being filed. So yeah. So it, we need all the letters we can get. And I promise you that Melissa is innocent, and there's a ton out there to prove she's innocent. I think I'm going to go live on Justice with Jax one day this week and talk about Melissa's case and plead with people to send Kathleen Zellner a letter. So, all right, I'm going to go because this has been 2 hours now. Thank you, everybody who joined me live. Thank you in advance to those who will watch this recording. Sorry you weren't able to be on live. Like I said, don't know when I will be live next. It's whenever Kathleen files, and when she responds, and I can go live. So, all right. Thank you. Investigation continues.